Good afternoon, everyone, and welcome to this seminar organized by the Singapore International Arbitration Center and the Society for Construction Law, Korea. My name is Michelle Sonin, and I am the head of Northeast Asia at SIAC. SIAC is delighted to host this event with our friends and colleagues at SCL Korea, and we are thrilled to be participating in the Seoul ADR Festival in person for the first time since COVID-19. For those who are here with us, thank you for joining us in person for this event. And a very warm welcome as well to those who are joining us online from around the world. I would also like to thank Yulchan for generously hosting this event in this beautiful seminar room and for providing the refreshments outside. Today's seminar will focus on global construction projects with the goal of better understanding emerging markets in Southeast Asia and the Middle East, and revisiting tried and tested dispute resolution methods. Before we begin, we are honored to have representatives from SIAC and SCL Korea give welcome addresses. May I first invite Mr. John Bang to the podium? John is a member of the SIAC Court of Arbitration and a senior partner at Peter & Kim. John?
Thank you, Michelle. Very good afternoon to everyone here in Seoul, and a good morning or evening if you're tuning in live stream from different parts of the world. I'm very pleased to welcome everyone to the seminar that's being co-hosted by the SIAC and the Society for Construction Law Korea chapter. As a member of the SIAC court, I am always happy to see SIAC leading the way in thought leadership. And I'm particularly pleased to see the collaboration with SCL for this event. After a couple of years of looking at people through screens, and we're still doing that a little bit today, but it's great to see many of you in person. I'm very excited for this event for a host of reasons. But most importantly, because it has put together a bunch of thoughtful market leading voices and given them two very interesting topics to reflect on. And I am certain that their comments will give everyone attending something to think about. The first panel dealing with the topic of how you best mitigate risk in construction projects in Southeast Asia and the Middle East will be a conversation that is set in the context of a pandemic and post-pandemic market. In the past decade, there's been an inflow of capital into the projects in the regions, but there's no running away from the fact that these markets are still reeling from the impacts of the pandemic, particularly delays. At the same time, there's never been a greater awareness about risks associated with the pandemic and in fact, military conflicts that need to be managed. I'm curious to hear and learn from the panelists on these questions and other localized risks that are emerging in the Middle East and Southeast Asia. The second panel deals with a familiar question that continues to serve as an interesting topic for debate and discussion. In recent years, there seemed to be a trend that multi-tier dispute resolution clauses were beneficial, and there was some sort of push for their adoption. Due to that push, multi-tiered clauses, which were common in construction disputes through negotiation or mediation or DRB boards, became even more widespread. It is stimulating now that we have a situation in both construction and general pure commercial disputes where courts in various jurisdictions have found that participation in the tiers that precede arbitration is not mandatory. There are also, of course, complicated situations that also arise dealing with the compatibility of contemporary measures like emergency arbitration and multi-tier clauses. In light of these the fast-paced developments, I am looking forward to hearing what our panelists have to say. Let me quickly wrap up by not delaying the proceedings any further. I will close by welcoming everyone who's traveled to Seoul. and to other for this event and other events. And unlike conferences where I stay, unlike virtual conferences where I stay in the office and continue to work, I look forward to enjoying cold beverages with everyone here. Thank you very much.
Thanks so much, John. May I now please invite Mr. Park Ki-jung to the podium? KJ is the chair of SCL Korea and a partner at Yulchon. KJ?
Thank you. It is my honor on behalf of SCL Korea and Yulchon to take this occasion to host and welcome everyone here today for our joint SIAC and SCL Korea seminar. It is also our great pleasure to have Mr. Pang with us today, who just presented us with his congratulatory remarks on behalf of the SIAC. And we are also honored to have opportunity today to host this seminar with some of the most recognized experts and lawyers in this field as speakers. The Society of Construction Law, SCL, in the UK was formally launched in London in 1983. Since its inception, the society has branched out to many different jurisdictions internationally and has become one of the most prestigious societies in the world in relation to construction law. With support and approval of our friends at SCL UK and SCL International, 3 years ago, SCL Korea was formed to contribute to the Korean construction industries through its common objects with 18 Korean experts who are now committee members, and you can see them in our website. Taking this opportunity, especially I would like to thank to S.Y. Lee, who inspired me and encouraged me to start SCL in Korea. The purpose of SCL Korea is specified by our constitution. As outlined in Article 2, which is to, I quote, contribute to the sound development of the domestic and overseas construction industry and the development of the national economy by carrying out various business activities such as education, research, information, provision, and publishing relating to domestic and international construction laws through independent, self-sustained, and autonomous society activities. In line with these objects, we have continued to achieve our goals through publishing papers and books, regular webinars, seminars, and group studies. As we continue making strides in realizing the objectives we have here at SCL Korea, we look forward to your continued interest and support. I will end my introductory remarks with an old African saying. If you want to go fast, go alone. But if you want to go far, go together. Thank you. Thank you.
Thank you so much, KJ. We will now get started with our first panel discussion entitled Mitigating Risk in Emerging Markets in Southeast Asia and the Middle East. May I please invite the speakers to the stage? I have the pleasure of moderating this session, and I will also shortly be taking my seat on the panel. But before that, let me introduce our speakers. Joining us are Ms. Anne Hoffman, an independent arbitrator based in Dubai, Mr. In Kim Beng, the Deputy Managing Partner at Raja & Tan Asia, based in Singapore, Mr. KJ Park, and Mr. Zachary Sharp, member of the YSIC Committee and partner at Jones Day in Singapore. Thank you all for joining us today. Just a quick housekeeping matter before we actually get started with the discussion. For our online and in-person participants, you are welcome to pose questions to the panelists. For in-person, please feel free to just raise your hand as we go along if something comes up. For our online attendees, please feel free to submit questions using the Q&A button, the Q&A function on Zoom. Okay, now let's go ahead and jump right in. Time is short and we've actually got quite a bit of ground to cover. So we are fortunate today to have with us experts in construction based in the Middle East and Southeast Asia and Korea. I would like to start by asking them to comment on the cultural considerations and or relevant laws that Korean companies should be aware of. So we'll turn first to Anne. Could you share some insights from the Middle East?
Yes, I'll be delighted to. And thank you for the invitation. It's a pleasure to be here in Seoul after what has been a long time since my last visit. But it's a pleasure, and I'm delighted to be able to share some of the insights with regards to the Middle East in particular today. So the first idea or the first question, the first topic we thought we wanted to address was both cultural considerations and some aspects of relevant laws, in particular Korean parties or companies coming to the Middle East should be aware of. Now, when it comes to culture, I think, that is a factor which might be underestimated, in particular when it comes to construction projects. When I talk about culture, I'm talking about values, perspectives, but also language and the attitude of people dealing undertaking transactions and doing projects in different parts of the world. And of course, when it comes to construction, that by default means that you have at least two different cultures meeting, when one side moves into, the territory of another to carry out a construction project. And I think it is important that any party involved, is cross-culturally aware when undertaking those projects, not just limited to how do I carry out a project, what are the hardcore construction components and factors that play a role. Different attitudes with regards to carrying out work generally, I think means that there's greater potential for conflict. And, it has been said that conflicts are inherent in any construction project, in particular because of that. So cultural issues, I do think, contribute to conflict. In particular, culture impacts the way people communicate, and it also impacts, particular points like the contract documentation, which I think any construction lawyer and arbitrator working in this field finds to be of particular importance. And so when dealing with this, I think, it is a point parties should be increasingly aware of, and organizational culture and leadership is in responsibility to make sure that differences, for example, between companies based in the Middle East and Korea, but for that matter anywhere, frankly, are being identified and potentially addressed. This ability, I think, is crucial. And what struck me when we talk about culture with regards to projects being carried out in the Middle East is I think that there is another additional complicating factor, and I'm interested to hear what maybe other people have to say about that, because in the Middle East, what you find is when you have a developer or you have a contractor, is that whilst, that project is being carried out in the Middle East, you often find people there on the ground who are not from the Middle East and who are not, for example, Emirati or Omani or wherever you are. But those companies are also employing people from around the world, and in particular, of course, from the Asian subcontinent, so India, Pakistan, etc. So I think you have an additional layer of complication where even if you go in and you think you've learned something about Middle Eastern culture, you find yourself dealing with people who are not necessarily Middle Eastern. And so there, I think, is an additional layer which complicates things, or potentially complicates things if not being addressed in any way, or being thought of at least, increasingly. That is a few thoughts on culture. Maybe we come to law a little bit later.
Sure. Thanks so much, Anne. That's very insightful, and a lot of things to consider when you're doing cross-border projects. So let's move back over to Asia, and I'll turn to Zach. If you could share your view from Singapore, and also as someone who formerly worked in Korea as counsel and in-house counsel.
Thank you. Is this on? Okay. So one of the most interesting things about Southeast Asia, and anyone who's been there recently and has some connection to Korea will notice this immediately, is the extent of Korean investment in the region. I mean, it's astounding to me that almost everywhere you go across Southeast Asia, you see major commercial complexes that are not just built by Korean contractors, but owned by Korean companies. You see Korean chains and throughout the region. And it's immediately evident that the Korean companies are there and they're there to do business. There has been across the region, Korean contractors have had a significant impact in some of the largest commercial developments and in some of the largest infrastructure developments. And so this is an area where I'm conscious that the Korean contractors already have a lot of experience in the wider region. But there still are a number of issues, I think, that come up or that sometimes catch people by surprise. And I wanted to address those here today. The first one, I think that comes as something of a surprise, although I think most Korean contractors are quite familiar with it now, is the prevalence of security of payment legislation and statutory adjudication regimes. So these regimes essentially allow contractors or subcontractors in respective commercial construction projects to submit payment claims and then require certain actions from the employer, or if you're the main contractor, from the main contractor within certain prescribed time periods. And the purpose of this legislation is to keep projects cash flow neutral and to keep them running. So they generally prescribe very tight time periods for responses. And if the contractor or the employer misses a response to a payment claim, they may have to pay out the claim subject to their right to recoup amounts that were wrongfully paid later. And there's security of payment legislation in Singapore, the security of payment legislation in Malaysia. Vietnam and Indonesia have security of payment type regimes or have been considering this type of legislation recently. It can be quite difficult to manage and can be quite onerous in the context of running a project to have to deal with all these claims because it typically flows through. So subcontractors, vendors for the project will also take the benefits of the regime. So it's something that needs to be kept in mind in the region. Liquidated damages is also, I think, a very important one because in the region, there's actually a lot of differences in terms of whether or not liquidated damages clauses are enforceable at all. And this is one that cuts both ways. So parties should be very tuned into it because sometimes you want the liquidated damages provision to take effect because you don't want to be exposed to a claim for general damages at law. Whereas sometimes if liquidated damages are quite high and onerous, you're perfectly happy having damages assessed on an alternative basis. This is something I think particularly if you're experienced or if the contractors are experienced with English common law type regimes where it's fairly difficult to avoid a liquidated damages clause. This is an area where people can get into trouble or get caught by surprise in the region. The last one, since we're talking about arbitration, I'll just mention briefly, which is arbitration laws themselves can be quite different between a number of the jurisdictions in the region. There, at a cultural level, there may be a lack of understanding of arbitration or a lack of understanding of the role of arbitration in contrast to the role of the courts. In Indonesia, for instance, you may have a counterparty that will go straight away to court if it has a complaint or concern, and you may end up having a dispute over whether or not you should be in arbitration or before the court at all. You also sometimes have mandatory time limits for proceedings. Indonesia and Vietnam both have mandatory time limits. And you can face a number of issues then in the context of an arbitration trying to comply with those. I'm going to pause there and hand back since I know that I've covered a lot of ground.
Thanks a lot, Zach. No, you did cover a lot of ground, but it's very useful stuff. And I think one takeaway for me personally, that it is important to have counsel that is experienced in wherever region you're doing business, to be aware of the types of quirks in terms of culture and also in the law in that jurisdiction. So I think Anne wanted to add on a little bit more. So I'll hand the floor over. And we are over time on this topic, but don't worry, we'll make it up somewhere else.
In light of Zach's comments, I wanted to add something with regards to the Middle East, which I think is actually not that far off with regards to, or, some of your points. So the Middle East, which I'm sure many of you know, and I maybe shouldn't generalize in terms of the Middle East because it's not a block, but some of the crucial jurisdictions, as the UAE, where I know Korean contractors are very busy, are civil law jurisdictions, with the slight quirk that within the UAE you have, so-called free zones, which have common law built into them, and some of them have their own court jurisdictions. That might be important with regards to arbitration, but I'll come to that in a moment. So a lot of them are civil law jurisdictions based on Egyptian law, where things have been derived, or the law has been derived from, the codes have been derived from. But it operates generally on, construction principles, or shall I say norms we know. So people are using FIDIC forms, often changed in favor of developers or employers, or amended in that regards. But there are certain civil law principles, which I think those who are familiar with common law principles might not, or are trained in common law, might not pay enough attention to. One of the points is liquidated damages, which is an area which also also is not as it might be for those who are familiar with common law principles. A similar concept of good faith is very prominent and important because it is a codified principle, and courts have the power to prohibit certain conduct that they might consider to be in breach of this principle of good faith. So there are some aspects which people should be aware of. And similarly, because of the prominent presence of common law practitioners, and particularly English practitioners in the law firms, you find that, even though the law is civil law, that you have common law principles mixed into contracts, and then therefore there might be a clash between, what is written in certain contracts and how are things enforceable or understood under, for example, UAE law. Just some considerations in addition.
Thanks so much, both of you. That's very, very helpful and insightful advice. So let's shift gears and talk about something, a concerning issue that can arise during a project, really in any jurisdiction, is when there's a change in the law that affects the project or your contract. And I'm going to ask KJ to talk a little bit about that and tell us how companies should respond.
Thank you. Recently, Yulchon had a construction seminar in Vietnam for Korean construction companies, in which I took part as one of the speakers. During the seminar, many companies complained that changes in a local law, which resulted in delay and additional cost, but mainly the employers did not compensate for the additional cost and EOT. In this scenario, what should be done? I would like to start with risks. So could you slide, please? As you can see on the slide, there are a lot of risks surrounding a construction project. How to share the risk is very critical for a project and as well as the party concerned. Most of standard form, including FIDIC, allocate risks fairly, but some bespoke contracts do not. hence, let's think about risks first. When it comes to risks in the construct contract, it can be divided into three groups: employees risk, or contractors risk, or shared risk. What is a shared risk? For example, force majeure event, such as war, for which both parties are not responsible, that is a shared risk. Generally, EOT allowed, but not additional cost, as you know. How about changes in laws? Whose risk? Well, it will be depending on the words in the contract. Well, the employer is generally better placed to predict for change to local laws, which will affect the project. Let's check it in FIDIC. Next page, please. Whose risks in FIDIC? Yes, that's employee's risk. That is to say, the contract could be remedied by EOT and additional cost. Most of contract accept this way, right? I'll look at a bit more detail of FIDIC here. I think 3 points we need to look at carefully. The first, what is change? Change to the law includes not only new laws or modification to old laws, but also changes of interpretation, as you can see in the slide. The second, what is country? Well, subclause 1162 is limited to changes of law in the country where the works are being carried out. And third point shall be, what is law? Also, the definition of law, subclause 1165, is very wide, covering all national or state legislation, statutes, ordinances, and other laws and regulations. And also, one of the most important issues you have to follow is that notice procedure. But there is no unforeseeable test in these FIDIC clauses. Well, in relating to COVID, many construction companies received some EOT through force majeure clause. In this respect, if an administrative order of a country had affected the construction work, it is necessary to examine whether the administrative order meets the relevant changes in laws clauses. And in theory, it may be possible to receive time extension and cost under the changes in law clauses if it meets all the requirements. Further, in some countries, prices and wages are to some extent determined by law or decree. In this case, if there is no fluctuation clause in your contract, you may consider and review the changes in law clauses. Yeah, that's it. I pass the mic.
Thanks a lot, KJ. And I know another issue that you had raised when we had our pre-panel discussion was EOT, extension of time events. Is there something you sort of wanted to add on to your comments with respect to extension of time?
May I speak on well, when we have the EOT in relation to, may I speak now? Well, I think, yeah, okay, yeah, maybe I think it's related to EOT events. Yes, okay. Well, I have not prepared much on EOT event, but I would like to touch upon the general concept of the EOT clauses. My question is that why does the EOT clause exist? For whose benefit? This is my question. employers, contractors, or PMC, or engineer, or expert, or lawyers? It will definitely help the contractors. But think about the employer. So when an event happened in which the contract is not responsible and the employer is responsible, but there is no mechanism for EOT event. So what happened? Well, we know as English lawyers very well, right? So in this case, a prevention principle applied. So time being at last, and then the contractor is entitled to finish the work within reasonable time. So in the sense of a reasonable time, it's very complicated. So it could be disaster to the employer. The answer could be a benefit for both parties, and also the engineer. It makes his life easy. Right? Yeah.
Great, thanks so much. So Zach, I know I had said in our pre-panel discussion that we'd come to you on changes in the law. So let me just check before we move on if that's something you wanted to add a few comments on before we then move to Kim Bang to add on his views.
Just very briefly on the changes in law topic. I think Pak Pionosanim said at the end of his presentation that these clauses need to be looked at carefully, and in the context of COVID-19, these clauses have become very important potentially for pursuing claims. And I think, I just wanted to echo that, and I think that's right. And most of these clauses are framed in very general terms that didn't have in mind a global pandemic and governmental measures in response to the global pandemic. So it's always, even though the starting point is always the contractual language, I think it's very important also to think about how, if you're pursuing those claims or if you're opposing those claims, how best you're presenting the position, keeping in mind that in particular in the arbitration context, I think a lot of arbitrators will want to reach a result that is fair to the parties. So those clauses, I think, have taken on a new life, and it remains to be seen, I think, how tribunals will work through those. And it's a very interesting issue at this time.
Thanks, Zane. Kim Bang, I'll now invite you to speak on EOT or changes in law or anything else that you'd like that's been covered so far. But just a little quick introduction. We know you've worked in infrastructure and construction disputes across the Southeast Asia region. So very grateful for your inputs on this as well.
Let me preface. Sorry about that. And also the registrants who are watching the live stream. I saw the attendee list, and it's also got a lot of lawyers, legal professionals, and experts who are very experienced in this field, so who can all probably school us or school me on the subjects that I'm about to share some observations and comments on. So please bear with me. I just wanted, Michelle, you gave me a carte blanche, or as using Anne's words, I'm just going to steer the conversation back to EOT that KJ talked about. And the aspect I wanted to touch on was actually talk about the force majeure as a ground for EOT. Part of the reason why I'm here, and I think all of the visitors coming to Seoul are delighted to be here, is because hopefully we've seen the back of COVID. But in as much as the restrictions have sort of relaxed on travel measures, etc., I don't think we've seen the end of it as far as claims relating to COVID are concerned. And certainly for the projects that we're involved in, the disputes that we're involved in, a recurring question is still whether the disruption and delays wrought by COVID is a ground for claims, is a ground for claiming extensions of time under the contract. KJ has mentioned this. Generally, we'll be looking for force majeure as a ground for extension of time in the contracts. One issue that first arose at the outset of COVID was that clients perhaps didn't appreciate that force majeure was a creature of contract and had to be specifically stipulated in the contract. And so we were getting inquiries about whether it was an avenue to claim force majeure as a relief, even though the contract didn't have that stipulation. I think that question has been resolved. But a more interesting question was whether for contracts that, even though they used the phrase force majeure, didn't actually provide much else by way of a definition. And again, we know that force majeure as a creature of contract would also require a fair bit worked into the contract in terms of defining what a force majeure event is and how the event is going to be determined. And for some of the more elaborate contracts, as all of you are familiar with, you have force majeure provisions that go through the whole page, starting from notices being conditions precedent to specific measures of when the event of force majeure starts to when it ends, and then being able to prove that that event has had a substantial or material impact on your obligation or your ability to perform your obligation. Now, that also speaks to a requirement on the contract management and administration part, which is the need for record keeping. And one of the issues we find ourselves embroiled in now, or clients find themselves embroiled in, is that while they may have a fairly elaborate force majeure clause, they don't have the record keeping to support them in making the force majeure EOT claims. That's one issue that we encountered. Another issue was the contracts that there were standard form contracts that didn't have this definition of force majeure clause. So we found that over the course of the 2-year period during COVID, some of these standard form contracts have actually been revised and now include a detailed definition of what force majeure is to enable claimants to rely on the clause more effectively. But while that was going on, one of the interesting developments, certainly in Singapore, is a judgment from the High Court, which took the view that just because a contract does not spell out how a force majeure event is meant to apply, does not mean that the court cannot give it effect. And the court took the view that force majeure provisions are by now so well known, particularly in the context of the circumstance of COVID, that it has to be given a certain reasonable reading. And so in effect, we had, at least in Singapore, a certain workings of a force majeure provision read into the contract as a result of this court decision. But you can see that all these developments really arose as a reaction to the need or the recognition of a response needed to deal with the inequities arising from COVID, to sort of level up the playing field, particularly for the contractors. The alternative to force majeure was the very blunt instrument of frustration. And there we get into an even deeper end, because you've got, as we all know, it's a common law concept. It discharges the performance, it discharges the contract. There's legislation that's in place to help to moderate its effects. But you have a whole variety of positions arrived at in different case law. You have Singapore cases where lease agreements were held to be frustrated because of COVID, in the sense that tenants who had gotten into leases to rent premises for certain F&B joints, etc., were found that they were justified in terminating a contract out of frustration because the purpose of the contract had been frustrated. The performance had been prevented or radically changed. And yet you have the same type of scenarios in English cases where the judge or the court came to a different landing. So frustration is also not the best response, perhaps. And so I'll conclude by sharing that Zach mentioned the adjudication legislation in Singapore that deals with cash flow. It's not a new concept. It's very widespread now in most of the common law jurisdictions. But one of the things that the Singapore government did as well to respond to COVID, as an alternative to force majeure, to frustration perhaps, was introducing the COVID Temporary Measures Act, or what we call COTMA for shorthand. Now that was pretty widespread and draconian because he essentially put a moratorium on parties being able to advance, to commence arbitration, to enforce judgments and adjudication determinations during the moratorium period. This is really just to allow contractors particularly to get the breathing space that they needed during the time of COVID. Those reliefs have now ended. The majority of them ceased earlier part of this year. So in conclusion, I just wanted to raise the point, and this is something that we were discussing at the opening reception yesterday, This year has been a bit of an odd year in terms of seeing disputes escalate into arbitration, etc. But the anticipation is that with all the release ending, the likelihood is we're going to see more of these disputes escalating in 2023.
Thanks very much. So we actually have a question from one of our Zoom attendees. So before we move on to the next topic, let me see if anybody wants to take on this question. And I'll try to paraphrase, and apologies to whoever asked it if I misparaphrase. So the question concerns the situation when an owner of a project is communicating verbally with the contractor on various types of decisions, including the target completion date, but didn't follow the protocol for changes that's set out in the contract. And then fast forward, they're going to be in a situation to impose liquidated damages. And then only then the owner is saying, well, you didn't follow we didn't follow the notice, the required protocol under the contract. How should a contractor respond to that kind of situation?
May I note what is protocol?
Well, the protocol wasn't the SCL. The question here specifically said didn't follow the contract protocol for changes. So no specification on what the appropriate protocol would have been. I think it's contractual provisions. Yeah.
Yeah, most of construction contracts does not have that kind of protocols. Maybe some procedure, I guess. So, for example, notice procedure. Well, if contracts fail to notice within some period of time, he loses his old entitlement. That's some clause saying that. So, well, maybe after he elaborated what is the protocol a bit more, then I can answer that question. That yes, yeah.
Thanks. Anybody else want to chime in on that one?
I think it's a very difficult question without looking at the contract language. I think there's really two issues. One is there's a question of compliance with the formal requirements for claiming an extension of time under the contract. So then there's an issue of whether or not the informal discussions would satisfy under the contractual regime for giving notice. Assuming that it doesn't, and if it's an English law contract, then there would potentially be a secondary question of whether or not the owner is stopped from claiming liquidated damages based on those discussions. So if the parties had agreed to proceed on the basis of a common assumption that that completion would occur at a later date, there's potentially an argument for estoppel in those circumstances, but it's very fact specific and it depends on the particular circumstances of the case.
And maybe the answer is before you even get there, just make sure you follow the notice provisions in the contract. Okay, let's move on. Stepping back from looking at specific claims, another very important part of dispute resolution for international projects is, of course, which forum will you be in? Large-scale projects often involve multiple contracts, which can result in separate proceedings on similar issues when a dispute arises. And consolidation can be a very important tool to resolve these related disputes in one forum. So if I could turn back to Kim Beng to shed some light on consolidation of proceedings, particularly involving disputes coming out of Southeast Asia.
Thank you, Michelle. So Raja and Tan Asia, we are in Southeast Asia, and that also happens to be the region which is a hotbed of activity for infrastructure development. Again, in conversations that we've been having, we've been talking about construction activities in Indonesia, in Vietnam, in Myanmar, and to a lesser degree, perhaps in Malaysia and Thailand. And a not uncommon feature in some of the contracting that's done in some of these jurisdictions is the requirement, because we're talking about large-scale infrastructure projects, there is international financing that's involved. There are international contractors who are brought in, who bring in their expertise, their design knowledge, as well as also even equipment. But on the other hand, there's also a requirement for a local component involvement. And that's where you have the device of the onshore-offshore contracts coming into play in some of these jurisdictions. They are, in our experience and observations, they are stacked differently. There are some onshore-offshore contracts which cleave a very bright line separating the obligations and responsibilities between the offshore contractor and the onshore contractor, separate contracts, separate governing laws, separate arbitration agreements, and also separate accountability to the developer or the owner. On the other hand, there are such contracts where even though they are separate creatures, they are joined together by, for example, an umbrella agreement, where the two offshore, onshore parties are then brought together to be held jointly and severally liable to the owner of the project. But my point is that you have these large-scale developments that involve multiple contracts. And prior to the amendments to the SIAC rules, and indeed following the amendment to SIAC rules, the other arbitration rules that incorporated this feature, which is to introduce a provision for consolidation of proceedings. That was a challenge. It posed a challenge when it came to arbitrating disputes arising out of multiple contracts, for reasons that everybody is familiar with: inconsistent findings, excessive time and costs, etc. So I would say that the consolidation provision in SIAC rules has been a very important feature that's been worked into the rules. It's, I believe, well, we've got Kevin here, he can comment later about how popularly invoked that clause is. Having said, I think still, even with the clause, there are still practical challenges, perhaps sometimes in giving it full effect. There are 3 grounds, if I recall correctly, for a consolidation application: agreement between the parties, the contracts, all coming under the same arbitration agreement, or the 3rd ground, which is probably the ground that's most commonly invoked, which is that the parties, well, there's a compatibility between the arbitration agreements. And then there are 3 different scenarios, one of which is that the contracts arise from the same transaction or same series of transactions, or the other scenario being that the contract is based on the disputes arise from a principal contract and related ancillary contracts. But it's in those details, the weeds, that the application actually becomes a little challenging. And it's not impossible, at least from our experience, it's not impossible to advance on this. And in fact, the rules have been very helpful in paving the way forward. The consequence is time. So we've had consolidation applications which have taken more than a year. We've had a consolidation application which has taken at least 3 months. But that time, particularly for some sorts of disputes and claims, can be costly in terms of the extension or the impact it has on the timescales.
Thanks very much. And indeed, consolidation is one of SIAC's most popular special procedures. I know we're getting short on time, but if anybody has any quick points to add, or Zach in particular on consolidation, otherwise we can move on to the next topic.
I yield the balance of my time.
Okay, somebody reset the clock for Zach back there. Okay. So actually our last topic is sort of taking a macro look and looking at COVID. But before we get there, let me address one additional comment from the audience, particularly on Zoom. And we talked about force majeure some moments ago. And so this question is in relation to force majeure clauses and where the statute does not have a clear definition of force majeure. How is the tribunal going to interpret a force majeure clause in the contract?
You're then considered the arbitrator who does this. But you first said that there is no contraction in the contract.
I think there is a force majeure clause. The assumption is that there is a force majeure clause in the contract, but there is no statutory definition of force majeure.
Okay. That's a very difficult question, and the lawyerly answer, I think, is it depends really, because as counsel, more than anyone, and I certainly am of the strong view it really depends on the party submissions. I don't think I can make assumptions on how I would interpret something without having seen what the parties put forward based on the facts of the case, and how they play out and which evidence is before me in light of the arbitration clause, and then having to look at what the parties are really pleading, because of course it's not up to me to make things up or put things in the party's mouth, if I want to put it this way. So I again, unfortunately, I don't think I can give a one decision fits it all kind of answer on the basis of which then everybody thinks, let's go and choose her as an arbitrator because this is what she's going to do. Unfortunately, I've seen situations where one would say, or the institution said, we're surprised you came to this conclusion based on, having seen similar scenarios. And of course, my answer is, but, each case is different and each case really depends on the facts and what the parties put before you. And I think that is ultimately what I have to say on that.
Thank you. Thank you. Anybody?
I thought,
anybody
Anne,
else?
to be fair, I better add some remarks since I put you on the spot there. But certainly from a counsel's perspective, I would say that that's definitely arguable. If you've got force majeure in your contract, I think it's definitely a good start to begin with to actually argue a relief based on force majeure. I suppose an added measure I would add to that is if you can provide for Singapore law being the governing law, because as I said earlier, there now is a High Court judgment that says that even if it's a bare force majeure clause, you've still got some grounds to advance a claim on that.
But even you wouldn't say, and therefore you're going to win with that.
Thank you both for that. Oh, sure. Go ahead, Keisha.
Yeah, I guess it depends on the jurisdictions. Yeah, definitely. And under the English law, maybe in the UK, there's no force majeure concept. And maybe definitely the tribunal will look at the contract and the clauses and then check the cases and how to interpret the contract. That is the way I guess, yeah.
Thank you all for that input. So now time is starting to run short and we do need to hand over to the second panel soon. So let's move on to our last topic, which is on the impact of COVID-19, specifically the continuing impact of COVID-19 on emerging markets. So Anne, we'll come back to you. What have you seen in the Middle East region and what do you foresee for the future?
Well, I remember that, when we looked at that, when we discussed this panel before, we looked at, the economic recovery in particular and how is that going? And, I can say being based in the Middle East, but again, the term Middle East is to be taken with caution, that at least sitting in Dubai, the clear signs are for or very strong recovery, bounce back, etc. So you see that in particular in the UAE, the COVID response had been very measured, and again, not the same from emirate to emirate, but again, particularly with Dubai, with the Dubai focus, there was a very measured and very reasonable, I think, response, which made sure that Dubai never fully shut down, and I think that meant that the ramping up isn't coming from all the way down, but it's actually kind of mid-level already, and together with some considerable and conscious changes to the law and the investment framework, that meant that, I think the UAE is doing really well. So for example, the recent changes we've seen over the last years means that there's now 100% ownership permitted in most sectors of economy for companies, which wasn't, the case before, where you had to have a 49 and 51 split, where, local owners had, the right to have 51% and you couldn't own your company fully. And that, of course, was a big obstacle to investment. That has changed. The commercial companies law has been amended. There has been significant changes to the visa laws and rules, which means, that you now can hold, under certain circumstances, 10-year visas independent of the company you work for. You have very mobile visas where, you can be one of those digital nomads and get a visa for Dubai. And all of that has led to a really strong boom, which you can see everywhere, which, is when you go every day out in the roads, from the traffic to the property sector. But I see it every day in my inbox by being offered new houses, which are being built anywhere and everywhere around in particular Dubai, but also the UAE at large. So you see that. That I think is one economy. The most staggering from all of them, I think, is Saudi Arabia, which people who travel frequently will tell you that they do not recognize the country from compared it 5 years ago to now. there's a total change, again, both in the legal framework, but also in everyday, life. So there's a really significant boom in particular the real estate market. And for example, it is now permitted that expand, to invest in the real estate funds as non-Saudis, which was not the case before. Saudi has established an investment promotion authority, and all of that is reflected in the FDI inflows. So you've seen between 2017 till 2021, the FDI inflows into the UAE have doubled. And so there, COVID really, didn't create a bigger bumper. And in Saudi, it's even more staggering. You have 13 times the FDI inflows compared to 2017. And I think those numbers speak a certain language, which, you can see when you go there, but also just in terms of sheer numbers, you see the rest of the Middle East is different. Kuwait, there's more of a downturn. Oman, there's more of a downturn. But in particular, those two, you can see, and particularly the investment and also the construction sector, which I think is particularly interesting here in Korea, see a massive upscale, and we see it everywhere. Just looking around in terms of projects which are being started and being continued. That's not to say that there's no scope for dispute, as we've said, on various levels, but at least there is no felt sort of sleep or dormancy anymore. So I think there's a strong message of at least Dubai, the UAE, and Saudi are back, and I think other economies hopefully will follow suit.
Thanks, Anne. Thanks very much. And then let's move back to Southeast Asia. We can have Kim Beng give your views.
I've got a minute, so I'll make it quick. To me, it's really just the tension and the conflict between costs and delivery. So yes, we're coming out of COVID, projects have restarted. Contractors in particular in infrastructure are having to deliver on promises that were locked in a number of years ago. And we're still facing, and they are faced with the challenges of sharply increasing costs because there are still movement controls, restrictions. Supplies of materials have really been restricted, and that's also driven up prices. And it's, well, at least from conversations again we've been having with professionals, with colleagues, there is a real concern, growing concern for these escalating costs and how that's going to be managed. On the other hand, there are governance requirements, etc., also dictate that owners, developers continue to hold contractors to the bargains as much as they can. As I mentioned earlier, with the reliefs that have now expired, provided by the legislation, etc., I think we're watching the space as to what's really going to be coming and how these issues and conflicts going to be resolved in the coming months.
Thank you. KJ, Zach, anything you would like to add or any other concluding thoughts?
None for me, except to say thank you to my co-panelists.
Thanks so much. Welcome back, everyone. We'll now get started with the second session entitled Revisiting Tier Dispute Resolution Clauses. Are they a friend or foe to construction disputes? Joining us as panelists are Mr. Anil Tangaroth, Managing Director of Tangaroth Chambers and Chair of the International Relations for the Society of Construction Law Singapore, Mr. Mino Han, member of the Publication Subcommittee of SCL Korea and partner at Peter & Kim, Ms. Sue Kim, International Liaison Committee Lead at SCL Korea and a Director at HKA, and she's based in London, and Mr. Kevin Nash, Registrar at SIAC, and he's based in our offices in Singapore. The discussion will be moderated by Mr. Jae-Hyung Woo, a member of the Papers Committee at SCL Korea and a partner at Yulchon LLC here in Korea. Jae-Hyung, over to you.
Thank you, Michelle. Hello, everyone. Thank you for joining our session today. During our session, you are going to deal with three interesting issues related to multi-tiered dispute resolution clauses. First, we'll question whether tiered dispute resolution clauses are a friend or foe in construction contracts. Second, we will focus on expert determination and discuss whether this is a helpful dispute resolution method. Last and but not least, we will talk about whether the legal systems and cultural background play a role in how parties perceive and make use of tiered dispute resolution clauses. We are planning to have a separate Q&A session at the end. All of you are actively invited to ask questions and to make remarks as well. So to start, before we move on to our questions, I would like to begin with a brief introduction to set the scene. I will then let our esteemed panelists to deal with the issues by sharing their experiences and knowledge in turn. First of all, what is multi-tiered dispute resolution clauses? Tiered dispute resolution clauses involve 2 or more steps in the overall dispute resolution process and incorporate certain dispute resolution methods which the parties are required to comply with in resolving the dispute between them. Tiered dispute resolution clauses contain different types and phases, such as negotiation, mediation, conciliation, or expert determination. These clauses typically require parties to participate in any combination of these processes before they may resort to litigation or arbitration at the final dispute resolution method. So I would like to start with our first issue and ask Anil to first share his insight on this issue.
Okay, so the first question is whether it's a friend or a foe, multi-tier dispute resolution clauses for construction works. My take is it's a friend, but not in the way it's currently set out, because as described what multi-tier dispute resolution clauses, it also been referred to as stepped or escalation clauses, that you take one step at a time and then move on up the ladder. My personal take is that I don't think we're there anymore. We're well beyond that. And I start off by just saying that, while many of us know it as alternate dispute resolution, I've been calling it for the last 10 years, appropriate dispute resolution, only because it's what's most appropriate under the circumstances. So we're long past the days when you look at alternate to arbitration or litigation, but what is most appropriate? And that's where you then realize that it's not necessary for you to have a step-by-step up the ladder and take it up to arbitration. And an example of that is the Singapore Institute of Architects have got a minor works contract, and I worked on it with the architects and on a quantity surveyor about 12 years ago. And in the dispute resolution section of that contract, we have mediation, expert determination, and arbitration all on the same level, not step by step. And the rationale for that was that if it was a highly technical issue, all you need is an expert determination on that. And the Singapore Institute of Architects has got expert determination rules. If you feel you want to keep your relationship going, then you go to mediation. And if you really don't think it's going to work out, then you go to arbitration. So we've kept them all on the same platform. At the time that we amended the contracts, the Singapore Institute of Architects contracts, we didn't really spend enough time thinking about the problems that might arise if one party takes one approach and the other party insists on the other approach. But we've never had a problem in court or otherwise at the moment. It seems to work fine. So while I say that the multi-tiered dispute resolution provisions are important for construction industry, it is just no longer necessary to go down the step-by-step process and then lead up to arbitration. Last point on that is this. There are a lot of case law in Hong Kong, Australia, Singapore, and the UK in the last two or 3 years. When the matter reaches arbitration, the question then is whether or not the parties had followed the multi-tier dispute resolution provisions, and if they're not, what is the effect? And so the court, I think the courts have agreed that arbitrations can still go on. It's not a jurisdictional issue, but it's more of a substantial issue of the whether or not you want to look at whether a question of damages for not having gone down the path of mediation, for example. And that's what the courts have been looking at. And that's it for now. That's all right.
Thank you, Anil, for sharing your insights. And can I then have Bino to share your experience and your knowledge, please?
Sure.
Anil, you said multi-tiered dispute resolution clauses are a friend to resolving construction disputes. Then you added a number of caveats, which to me sounds that you're in fact advocating for the proposition it's an enemy. Anyway, I think it's an enemy for a number of reasons. The construction dispute needs to be resolved generally efficiently, and that includes time and cost efficiency. And it often arises at the end of a project, meaning that those negotiations or mediations being forced upon a contractor often don't work. It's already so broken, the relationship, that such forced mechanisms are just a waste of time often. I'm not against having negotiation or mediation in between an arbitration. You can call it ARB, med-ARB, or whatever. And in my experience, mediation is effective when the dispute reaches a certain level of ripeness and the issues are crystallized. That's a different story, I think, from imposing an obligation on the parties to must do it. And in the absence of complying with it, having that sort of as a precondition to an arbitration, saying that arbitration is not possible as a jurisdictional matter, and leaving that seat until the end, even until enforcement stage, only increases unstableness and insecurity. So I'd say yes, mediation, yes, negotiation, mixing that up with arbitration flexibility is good, but having that as a sort of mandatory contractual requirement is actually not helpful in many cases.
Thank you. Kevin, do you have any thoughts on this issue?
I'm thinking when we're discussing whether this is a friend or foe, maybe it's like one of the online platforms where the real answer is that it's complicated. From our standpoint at an arbitral institution, we see these cases when these preconditions have not worked. So there's any number of cases that you all would see as counsel where the preconditions are successful. I think it's impossible to get away from the fact that this is also a drafting consideration as well. If you look at the average time from a transaction to the eventual dispute, that might be 2 years, it might be 3 years. Do you know the exact circumstances and the color and contour of that dispute 3 years from the time of transaction? Or say if you're in Singapore, if you end up against the limitation period, if it's 6 years. So if you've contracted for, say, 30 days of structured negotiation that end up across that limitation period, what is going to happen then? What if you need urgent interim relief in the context of a precondition to arbitration? So there are some drafting considerations that you want to take into account. And the idea is that parties are going to be negotiating anyways, even if it's not specifically codified in the arbitration clause. Mino, you mentioned ARB med ARB, and I certainly think that that is an idea that cures some of these potential pitfalls. So you get the crystallization of the commencement date of arbitration. You then have a tribunal constituted. The parties are free to explore mediation thereafter. This is something that we have in conjunction with the Singapore International Mediation Center. And during Singapore Convention Week, I was attempting to be a bit provocative, and I was saying how many cases that we'd had, and it seemed like a lot, but why isn't it more? Because it's very low risk. This could be suitable for a very high value case or a low value case. If you're not able to come to a mediated agreement, you have a standing tribunal, and then you're able to go back to that tribunal. Perhaps the parties have a better idea in mind of the strength of their case. What we sometimes see is even in the event of the parties do not reach a mediated agreement, there may be a settlement down the road. So they go back to arbitration, and then there's a settlement 2 or 3 months after the fact. I think it's also important to look at it across jurisdictions. Anil, you mentioned that there is a lot of emerging case law, particularly in the past 2 or 3 years. Is this a question of jurisdiction or admissibility? That is going to be an important issue, and I think that you want to know what the playing field is, where you are. From SIAC's standpoint, what you might get there with jurisdiction and admissibility being two sides of the same coin to a certain degree. This is a case where you may have, say, John Bang and the other members of the SIAC court taking a call on a prima facie jurisdictional objection. So it's complicated. It can be effective, but certainly from a drafting standpoint, these preconditions need to be handled with care.
Right. I'm really good to be the last speaker, having listened to all the answers. So Anil is in favor of a friend with lots of caveats, and Mino is in favor of 4, and Kevin is says complicated, right? So my point is there's no black and white answer to this question. I think it depends. It depends on the nature and fact of the case and which party you act for. So, for example, for receiving party of the payment who has a strong case, a tier dispute resolution clause may be a cause of unwanted delay, so it's a 4. Whereas for a paying party who want to delay the payment, so it's a friend. And also, as Kevin briefly mentioned, that how well your multi-tier dispute resolution clause is drafted is really important. So my health warning is that such clause must be sufficiently clear and certain. But generally, I suggest multi-tier dispute resolution clauses are useful. I say this for 4 main reasons. Firstly, they put ADR on the agenda. So this ensures that ADR is automatically considered once a dispute arises. Secondly, by specifying a particular ADR procedure in advance of the dispute, parties don't have to lose their face because it's simply the operation of the contract. Without such clauses, it'll be difficult for the parties to agree which ADR method to use once the dispute arises. My third point is, if ADR is successful, of course, the multi-tier dispute resolution clauses are a time and cost-effective way of managing disputes, because they may, at very least, enable the parties to narrow down the issues to be arbitrated or litigated. And fourthly, they can help to take the hit out of the situation by allowing for a cooling off period of discussion and negotiation. So during this cooling off period, the parties can reassess and sit back and reassess, evaluate the possibility of seeking a compromise outside of arbitration or litigation context. So such clauses can minimize the disruption to the project and the businesses, encourage a more collaborative working, and help to preserve and commercial relationships. But again, as I said to you at the beginning, there's no black and white answer. So I'm just going to add what's the downside. So on the other hand, the main disadvantage of tier dispute resolution clauses is that they may result in the parties being contractually bound to engage in the dispute resolution processes that they do not like or want. For example, a contractor may, on the fact, have a really strong case to be paid for additional works, so strong that there's no realistic prospect of the employer avoiding any liability to pay. But the tier dispute resolution clauses force the contractor to delay securing payment because they have to go through the agreed process. Secondly, another potential disadvantage is the timing, because the beginning of the dispute may be too early for the parties to realistically agree a compromise. For example, I was involved in this mediation for about 5 years ago. I was one of the quantum expert witness team. And the mediation commenced too early into the dispute resolution process. So each party's cost for lawyers and experts were double than the dispute value, and it took years to resolve. So my third point is multi-tier dispute resolution clauses are, of course, inherently risky in the sense that the parties don't know what kind of dispute may arise. because nobody has a crystal ball. So it's very often the case that the steps to be taken before litigation arbitration may not be appropriate for the type of dispute that arises later. So inevitably it will lead to excessive cost and the time to resolve the dispute. I think it was Daniel mentioned about the type of disputes as well. So lastly, multi-tier dispute resolution clauses they're ambiguously drafted, can cause more dispute and more expenses, not less. So again, I emphasize Kevin's point that I repeat my health warning that such clause need to be carefully drafted.
Just one additional remark, if I may. Both Kevin and Sue mentioned drafting, and Sue made a valid point. It depends on which side you are, and wanted to share with the audience food for thought on a case that I'm working on at the moment, where the contract says the parties shall negotiate the dispute in good faith prior to commencing arbitration. The contract is governed under UAE law. Okay, what is negotiation? What is good faith? There is no period specified in the contract. We are claimant. The other side, of course, raised a jurisdictional objection. We say we have negotiated in good faith. So it creates a bunch of uncertainties, which is sort of not really helpful in timely and cost efficiently resolving a dispute. We say as claimant.
But can we say, as we analyze this friendship, and I agree with all the positives and the negatives that you said, that this is a reality of modern dispute resolution. So whether they may end up being a bit wobbly, and so for my part, having seen a few thousand clauses over the years, these are now these existing clauses. So whether it says very vague language that's not very effective to the point, and with maybe a nod to, I think, 2014 English case, friendly negotiations, or the parties shall attempt to resolve the dispute amicably. So is that going to be a prohibition to arbitration? Maybe, maybe not, probably not. Certainly the position in Singapore is it needs to be specific. And if you've specifically contracted, say, for a 30-day period of structured negotiations, then you're likely going to be bound to that bargain. It's interesting for my part because I work at an arbitral institute. I find myself to be really an arbitration fundamentalist, but at the end of the day, we are in the business of resolving disputes for all of us. So the real advantage, maybe that we're not really touching on for some of these preconditions, is that they're fast and cheap and they can be decided during the lifetime of the project. So you don't have to go to that adversarial system. I mean, that's the real advantage. I can think of a few cases that we've had. I think that maybe we've got some cases that are pushing 10 billion under SIAC's administration right now, but we also have a case that I've seen that's 800 Singapore dollars. I think it's actually twinned with a $1,500 twin case alongside. And so what we do, which is an interesting choice as an institution, certainly you don't want to be too proactive, but we may invite the parties to consider mediation, because we're looking at that case and we're wondering, is that adversarial institutional arbitration the best approach for this case? Sorry.
Just 2 points, 2 points from what Kevin has said. That's why I said that it was a plus, because it gives parties the opportunity to think about the options that are available. All right. And I think maybe the best way that I should sum up what I started off with is to take out the word tier, just multiple dispute resolution provisions. And that's why I said the Singapore Institute of Architects has that set in the same platform, right? So it gives parties the opportunity to think about a faster, more efficient method of dispute resolution that gets them what they want. That's point number one. The second point I wanted to make on Kevin's point about being a arbitration institute is this: all the case law, the recent case law, all are in favor of saying arbitration can go on. It's not a jurisdictional issue. It's just an admission issue, admissibility issue, and whether or not you want to look at damages. So I just quickly cite 2021 English case, NWA. You have High Court of Hong Kong 2021 C versus D. In Australia, 2022 case, and then in Singapore, 2020 case. All of them have said when we end the arbitration, the intention eventually was to arbitrate. Insofar as the dispute resolution, tiered resolution clauses are concerned, well, there was an intention for them to look at that, but that doesn't mean we can't have this matter resolved at the arbitration. So insofar as arbitration is concerned, I think you're in a safe place, but the multi-tier dispute resolution clauses give parties an opportunity to look at it. Listen, there's far many more different methods. So there's neutral evaluation, for example, as well, right? And all of these things are things that we should consider seriously, all right?
Thank you all.
Without any intention to delay any further, I just wanted to ask one question to Anil. So you just mentioned that, I mean, we just talked about it, that such clauses must be sufficiently certain and clear, but that the example you gave us was that it's not tiered dispute resolution clauses, but it's multi-dispute resolution clauses. But for example, if the contract clause says, gives some options like negotiation, mediation, or expert determination, if there is any disagreement between the parties, which option we're going to go for. One party wanted to go to mediation. The other party wanted to go for expert determination, which is our second question. Say, for example, it's a technical dispute. So I want to go for expert determination. How would you resolve that?
Typical lawyer's answer depends. Right, depends on the circumstances of the matter. Exactly what we had with the Singapore Institute of Architects form. We had all three in the same platform because that's what we fundamentally wanted. We're still trying to grab around the fact of what happens if one party says, I want an expert determination. I suppose if you say expert, we'll come to that question about experts, so I'll leave that out. If it comes to mediation and arbitration, I think everything else in the world has caught up with our contract, because now you have the Singapore Convention, which allows, enforceability and all those things. So when you sit down with parties, and if you look at the Singapore Institute of Architects form and you ask the question, do we mediate or do we arbitrate? Right? And surely I think parties would come to a consensus which one they want to do. So we won't have a problem of, I don't care, I'm going to take you to arbitration, and I don't care, I'm going to take you to mediation. I don't think we'll have that problem.
Yes, I think we can talk this issue all day long, but just before moving on, I think will also have the same thought that I have in my mind, but in Korea, there's the issue of optional arbitration clause. So the Korean courts do not enforce such arbitration clause together with option of a mediation or other like litigation or other options available. So I think it depends, and we have to look at the laws governing the arbitration agreement as well. Thank you all for your very fruitful thoughts. And now we want to move on to our next question, which is expert determination. Expert determination is a form of alternative dispute resolution whereby the parties ask an independent expert to give a binding decision on their dispute. Expert determination is usually final and binding on the parties, and there is no right of appeal. It is particularly used in disputes concerning valuation or, as Anil mentioned, in technical disputes. Sue, I know you are a certified expert determiner, so can you please start off?
Thank you very much. My short answer to this question is yes, expert determination is a very helpful dispute resolution method, especially in construction contracts. It's particularly useful to resolve technical disputes, as you all know, where true expertise is required to reach a decision and where the relevant facts are not significantly contested and can be ascertained from documentary evidence. I'm going to talk about both sides of positions. As a certified expert determiner, I'd like to present, first of all, three main benefits of expert determination. First benefit is expert determination is relatively quicker and more cost-effective means of resolving a dispute than arbitration or litigation, which can, as you know, often takes years to reach a conclusion. It has a shorter timetable, which based on my experience is similar to an adjudication timetable, about like 30 odd days. An expert with specialist technical knowledge, whether it's a valuation expert or a technical expert, directly relevant to the dispute, make a determination. So again, save on time and cost. And it can be used in conjunction with mediation and adjudication, i.e. other ADR methods. And the parties can resolve parts of the dispute about which they would prefer not to mediate, thereby reducing the time and cost. in resolving dispute. An expert determination can be used to determine a specific issue in dispute, thereby not throwing every issue straight into arbitration or litigation. The second benefit is expert determination provisions can be provided in the contract, and also an ad hoc post-dispute agreement can be made. So it's flexible. The procedures can be controlled by the procedures are controlled by the parties, not by a court or arbitration rules. Third benefit is by prior agreement of the parties, the expert determinants decisions can be final and binding on the parties, as Jae-Young just mentioned at the beginning. And there are the limited ground for appeal or challenge in the absence of fraud or manifest error. So as you can see, this can provide the certainty of the final decision and prevent disputes running on for longer than necessary. So the parties actually can move on with their life. But same as everything else, there are always downsides for expert determination as well. The first downside is that there's often lack of misunderstanding around expert determination. I've seen the parties use conflicting terminology. For example, the expert shall act as an arbitrator, as you know, which is wrong. Because expert is appointed as an expert, which is different from expert witness, because the expert witness, as you know, is there. Their role is to assist the court or tribunal, whereas expert in expert determination is there to make a final and binding determination subject to the contract clause. And so expert is appointed as an expert, not as a judge or the arbitrator. The second downside is, unlike arbitration or adjudication, there's no default, I'm talking about the UK perspective, there's no default statutory framework or rules of procedure for expert determination along the lines of the Arbitration Act 1996 or the Housing Grant Act. It's purely governed by what the parties have agreed in their contract. Third downside is expert determination is unlikely to be appropriate for disputes involving significant factual and legal issues because of lack of ability to compel evidence from witnesses and the disclosure. And lastly, enforcement may also be a problem, because an expert decision is not directly enforceable, unlike a court judgment or arbitral award. Instead, if a party fails to comply with an expert decision, then the other party must sue for breach of contract and obtain a further court judgment or arbitral award to enforce the decision. So as a result, if you talk about international enforcement, the parties should carefully consider the extent that international enforcement of expert decision may be required. So now I hand off to Mina.
Thanks, Sue. I don't have much to add, and I agree with you, including because the way how technical issues are determined in an arbitration often have a lot of shortcomings, I would say. You have a technical issue, you have a party appointed expert on one side, and then you have a party appointed expert on the other side, talking about the same technical issue, but having a completely different sort of opinion. And the tribunal is left with totally two sort of different technical opinions in a polar way of sort of distance. There are measures that tribunal members do adopt to mitigate this issue. There are arbitrators who say, come with a joint statement first, for instance. There are arbitrators who say, let's do a lot of expert witness conferencing to mitigate this gap, and so on. But having said that, these shortcomings, I think, could be also overcome by a lot more use of expert determination. Having said that, I haven't seen so many, or at least me personally, haven't experienced so many expert determination sort of dispute resolution cases in Korea or involving Korean contractors, and I'm curious why, but would like to see more.
I don't have much to add either, but it is a relatively little known feature of SIAC. The parties will sometimes specify that the president of the SIAC Court of Arbitration will appoint the experts. So we do a few of these a year. We're working with the SIAC court right now on a court project where we are going to try to get a bit more structure to these appointments. So effectively a practice note for the appointment of experts and neutrals. To me, when I'm looking at expert determination, really the big takeaway is international portability of the award. So can be very effective for domestic disputes. And it's also a bit of a clarion call for arbitral institutions because there's some very good features of expert determination. But if you had an institution and under institutional rules where, say, there was a preliminary determination on a point of law, or if you had a small claims procedure, or just making sure that you have user confidence that you're appointing sector specialists. Because if you have a very technical issue that would be appropriate for an expert to decide, say in a multi-party appointment, if the institution is appointing all three arbitrators in a highly technical construction case, do you make sure that you have the expert in procedure, the sector expert, and all of the bases covered across the three-member tribunal? So I look at the good features of expert determination and wonder, what can we do more in arbitration? So we already have expedited procedure, but can it be, say, like the Swiss chambers, can you have a super expedited procedure? Can we make it even faster? Should we be thinking about a different schedule of fees as well for these some of these smaller value cases? Would it be covered by a preliminary point of law? So I think lots to think about for institutions, and these are these expert appointments we do see a few times a year at SIAC in any event where we're making the appointment.
All right, so I'm going to conclude this section with two examples. I was 12 years ago, I was in-house with one of the largest quantity surveyors in Singapore, Davis Langdon Sia. Gary Miles, who's here in the audience, was also part of that group. Two experiences there. We had an arbitration where I was kind of like shadowing with the chairman of the company. He wasn't arbitration trained, so the parties had fun in the fact that they were paying for one arbitrator, but they had a lawyer trained in arbitration to deal with it. We had experts come on board. I think this is Mino's point. It was horrendous because I don't know, before I had come on, the arbitrator had decided and directed that the two experts would give a single joint statement, and each of the experts would be allowed to reply to the joint statement, one in blue color and the other one in green color. And they had a reply to the replies. So then there was in purple color and God knows what. So we took 3 weeks with the experts. We broke, then I had left in-house, gone back to practice. By the time that the matter was reheard, one of the experts had a heart attack, so they had to be adjourned as well. Right, so that's the horror story. But more importantly, just 6 months while I was with Davis Langdon Sia, we had a high court matter that there was a judge, Justice Quinton Lowe, who deals with construction matters. He had, it was there was a gap in between the hearing dates, and there were about 15 more issues to be dealt with. And he told parties to come to Davis Langdon Sia and see the chairman for an expert determination on 5 of those issues. So they came to us. This is 12 years ago. We had no clue what expert determination was. We just had the instructions from the judge. So we sat down, the chairman and I, we sat down and we formulated the terms of reference. And we had parties agree to it, that they will submit all of the necessary documents. We would make an expert determination. They'd be bound by that determination when they got back to court. And we did that. And it was such a success because when they went back to court, they not only settled those 5 issues out of the 15, but it kind of like ticked off another 4 or 5 more issues, right? And that was an expert determination. So that's the kind of examples that we are exposed to. And remember, I repeatedly said the Singapore Institute of Architects have got an expert determination as well. So if it's really highly technical and it doesn't involve facts, I think Sue had mentioned that, you can go down that path and it's really quite helpful, right? That's it. Thank you.
Can I just add one more point? Just one more point. Although I just mentioned earlier, like the expert determination is not appropriate for any dispute involving significant factual or legal issues. I have come across this experience early this year and last year. I was involved in this adjudication, and early last year, during the adjudication, we had to refer to the decision made by the expert determiner last year, but he's a kind of well-known English judge, but he did make an expert determination on the point of law, but it was really specific issue. So they dealt with that issue. He dealt with that issue really quick, within about 30 days. And during the course of adjudication, we can refer to the expert. I'm a really big fan of expert determination because it can be used in conjunction with any ADR method. Thank you.
Thank you all for your thoughts. As we are running out of time, and although we have prepared, all of us have prepared for our third issue, I would rather open the floor for any questions, because we are having an in-person event in a very long time. So we already have a question from our online participants. The question is, Bino considers the mandatory pre-arbitration step of a dispute adjudication board to be unhelpful to the proper resolution of construction dispute. Would it be possible to comment on the usefulness of the role of the DAB process? So, can you please make an answer to this question?
Sure, I understand this question to be, if you say, multi-tiered dispute resolution clauses are unhelpful, what do we do about the DAB/DAAB clauses and mechanisms? I think there is a distinction to be made between a construction dispute that is sort of coming at the end of a project, a full-fledged, a big ripe dispute, versus the matters that arise during a project and that can be escalated to a DAB or a DAAB, resolved contemporaneously, which I think is very helpful to reduce the number of disputes that end up at the end of the project. So I'm not against DAB or DAAB. I think it's a helpful mechanism, and would like to distinguish that with what I said. Now, this sort of ties in with the third issue that we had in mind addressing, but are not going to, which is culture in the context of multi-tiered dispute resolution, not only language, but I think also legal culture. You have adjudication in common law countries, say in England or in Singapore, and you have that mechanism called pre-action mediation. It's sort of when you start a court case, before that you need to attempt mediation, otherwise you will have sort of either cost consequences or the court will say, go back and do mediation. In a culture like that, where the civil litigation system is structured in a way that you're used to have mandatory mediation in advance, I think it's more likely or sort of more understandable to have a similar step-by-step mechanism in an international project. Whereas if you don't share that same culture between contractor and employer, and you sit down and you're unfamiliar with that, then it's much more to sort of make fruitful use of that process. So that's why I advocated at the beginning against multi-tiered dispute resolution clauses in general.
Could I just add on? Something I shared earlier on in a mediation session we had earlier on. I sit on a dispute board in a matter involving a German organization and a project that's being done in Indonesia. And when they were contracting and drafting the dispute board element of it, I had insisted that they look at mediation as well as a step. From the German side wasn't a problem, but for the Indonesians was a little bit of a trick getting there. But we haven't had it's an ad hoc, so I haven't had a situation where I had to go and impose on them, let's start looking at mediation, or do you want a dispute board hearing on the matter, right? So that leads to this cultural point as well, which is the last question that we were going to deal with. So different countries and different cultures have got different approaches. Some of them feel that some of these mechanisms are don't make them strong, don't make the parties feel safe with their lawyers, for example, or they feel that they are being in a weaker position. But all I have to say is on that is that the world has changed so much. COVID has put us all on the same platform. The Singapore Convention has taken us a great step forward. So people and cultures are going to start to realize that there are methods of dispute resolution that far outweigh the traditional methods of arbitration and litigation. Parties are going to realize that, I really don't need to take this to court. I really don't need to be standing there and showing off that I'm a stronger man. But let's just try and solve the problem. So, you have all of these things that culturally are going to make a big difference.
Thank you very much. And I would like to ask whether there is any question from the audience or any remarks. If not, yes. Then we'll briefly talk about the cultural differences and how legal system and cultural background play a role in utilizing the tiered dispute resolution.
Well, it's interesting. We have such an eminent audience. We could probably pitch some questions to the floor as well that we want answers to. Yeah, I mean, in terms of culture, we were talking about it this morning, Michelle, Anil, and me, that certainly there's a culture of international arbitration to a certain degree. So I think that Singapore practitioners, Korean practitioners, they have a lot in common. So this common law, civil law divide, it does exist, but certainly in Singapore, where you've got Singapore and Malaysia surrounded by civil law jurisdictions, everything that we do in Singapore, particularly in the context of the SIAC rules, we're really trying to give effect to both the common law tradition and the civil law tradition. And that's very important in the appointment of arbitrators as well. So whether or not there's a divide and cultural leanings at the drafting of an arbitration clause, how an arbitrator adjudicates a dispute may be informed by whether they grew up in the common law or civil law. I think if I was to make almost with lots of qualifications of it depends and a very broad generalization, I think there is more of a culture of conciliation in Asian jurisdictions. And I think this is a very good thing. I think this has been attenuated as well during the COVID-19 pandemic. I think that the way that users, practitioners, arbitral institutions all worked together and actually cared about resolving the dispute rather than getting to a final award, I think that was a really good thing. It was important for supply chains and to keep commerce going. And as I said earlier, it is very typical for us to see a clause where there is some manner of precondition. Now, whether this has been thoughtfully drafted or perhaps it's been drafted in a bit of a loose way will inform perhaps a protracted jurisdictional phase, but it is a reality of modern dispute resolution across cultures, as parties do seem to like these preconditions and they can be useful for certain types of disputes, whether common law or civil law.
I completely echo what Anil and Kevin said. So the cultural background definitely makes a difference. So whether multi-tier dispute resolution that we talked about today is appropriate, depending on the location of the dispute and also the relationship of the parties. So I understand that culturally, some countries have a history of preferring the dispute to resolve dispute amicably and privately. Whereas, so they see litigation is kind of like embarrassment to go to the court to resolve a dispute. But because I'm based in London, I just want to share my observation in terms of what's going on in the UK. I think the UK has a history of resolving matters in court. And at the moment, I don't think there's a strong culture of preferring ADR in the UK. But then the main deterrent going to the court or arbitration is that I think it's the same everywhere, really. The litigation and arbitration is now extremely expensive. Not just the cost of lawyers, but cost of expert and all those people involved in arbitration litigation process. And it takes ages to resolve. And I spoke to one of the contractors yesterday, Korean contractors yesterday. They're going to have to make a decision whether to go to arbitration or not. But then they do know it's going to take ages to get the final conclusion. So in other words, financial reasons encourage the use of ADR. However, the use of multi-tier dispute resolution clauses is likely to increase because the UK civil procedure rules are 100% behind encouraging ADR, and the English courts actively encourage participation in mediation or other forms of ADR, for example, CPR based expressly mentioned early neutral evaluation. So, but ADR is not mandatory yet, but the current master rules, Sir Geoffrey Voss has made it clear he wants mediation to become compulsory for all civil cases. And also the Commercial Court Guide 2022 revision is now referring to ADR as negotiated dispute resolution, NDR, rather than alternative dispute resolution. So I think the mediation and the forms of ADR are no longer perceived as being alternative to litigation, which is in line with what Anil mentioned at the beginning. It's not alternative anymore, it's appropriate dispute resolution. And also lastly, the consequences of ignoring a multi-tier dispute resolution clauses also need to be kept in mind. In a nutshell, as Mino mentioned earlier on, like if a party unreasonably has acted unreasonably in ignoring multi-tier dispute resolution clauses or ADR by, for example, prematurely commencing arbitration or court proceedings, the likely consequences is that the court has its discretion to stay the proceedings or to enable the agreed process to take place, and the court may make an adverse course order. So I pass over to Anil.
Quick, just one point is that understanding of what dispute resolution, the appropriate dispute resolution mechanisms. In my practice in Singapore, the number of lawyers who still don't understand all of the different methods, it's kind of shocking, right? And then you have to really sit down with them and explain to them that you have this whole side that is adjudicative and the whole side that you get parties. And I've had one lawyer friend of mine who had started off an ADR company, and every 3 months when I kept telling her to update her website, and it's not just mediation, she'd ask me, so what's adjudication? Then 2 months later, she said, so what's expert determination? And we never got it off the ground. So it's been 3-4 years now, and it's dead in the water. So understanding and appreciating what these dispute resolution clauses are, or these dispute resolution mechanisms are and how it works is really fundamental to getting the culture right as well.
Thank you all. I think we are slightly over time. We received few questions from our online audience, but unfortunately, I think we'll deal these questions maybe through our SCL Korea's website or during our next event. So yeah, I would like to have Michelle for the closing remarks. And thank you all for attending our second session. Thank you.
Thanks very much to the panel for that very engaging, insightful discussion. This now concludes today's event. And once again, we would like to thank all our in-person attendees for being with us today, and also to our online participants. Thank you very much for logging in. Before you leave today, we would be grateful if you could spare some time to complete an online feedback form, which is, there's a QR code here that's obscured by our speakers, but perhaps on your way out, if you could just try to scan it and complete the form, that would be very great. We'd be very grateful. To our online attendees, I believe it's being circulated through the chat function. Thank you all very much. I hope you have a wonderful time at the rest of the Seoul ADR Festival. We look forward to seeing you at future SIAC and SCL Korea events. Thank you.